bill. They suspected she had dementia, and she didn't have an alternate agent under her power of attorney, and the agent under her power of attorney was no longer available. Their monthly bill was about $10,000 a month, and without an alternate, she needed a new power of attorney. So they asked me if I could come down and visit with her. Now, I hadn't seen Ruth. Now, that's not her real name, but this is a true story, and we'll talk more about it through the course of this talk. But I hadn't seen Ruth in over 10 years. So when was the last time you reviewed your estate plan? If you had a crisis, such as a stroke, a heart attack, onset dementia, and ended up in a hospital or a nursing home, are your legal documents up to date? Is your power of attorney up to date? So proper preparation in advance gives you the best chances of staying in control over the future. Now, we all know how to prepare for a hurricane, but are we prepared for a medical crisis that renders us incapacitated? We know that if we wait until the last minute, we risk losing control. I live on the beach near Windward, on Windward, Oahu, and Douglas was supposed to be a direct hit. So we did a lot to prepare for that. I made a list of things to do. Now, we didn't get hit, but I'm keeping that list for the next time. It's a pretty comprehensive list. So during the next 45 minutes, we will try to help you make a list so you can get all your ducks in a row. So what does it mean to be incapacitated? Now, they told me that Ruth had dementia. She hadn't been officially diagnosed, so I went to visit her. And she did seem confused. She didn't remember who I was. She was in a wheelchair and she was not able to care for herself. She could talk, but her hearing seemed very impaired. I had to talk very slowly and very loudly for her to be able to comprehend or seem to understand what I was saying. Now, there's both cognitive incapacity and physical incapacity, and there are combinations of both.
Sorry.
Okay. Oh, we got that? Okay, there's both cognitive and physical incapacity and combinations. Now, with cognitive incapacity, if you've seen one, you've seen one. Each case is unique, each case is different. To have cognitive capacity is to have the ability to understand the consequences of your actions and to be able to make rational decisions. For estate planning, such as a will, a trust, a power of attorney, there are essentially three requirements. When a person comes into me for a will and I have any kind of a question about their capacity, though there's always three questions that we need to ask. First is, do you know what you own? It doesn't have to be real specific, but generally, do you own a home? Do you have money in the bank? Approximately how much do you have in the bank? Do you have investments? Approximately what's the size of your estate? They have to kind of have a general idea of what they own. Secondly, do you know who the natural objects of your bounty are? In other words, tell me about your family. How many children do you have? How many grandchildren? Do you have brothers or sisters? Are they still living? And thirdly, that the person has a reason, a rational plan. I don't have to agree with the reason, but I'll ask the questions. Well, why do you want to leave so-and-so out of your will? And just to determine whether there is a rational plan. Now, even if a person has a mild dementia, they still may be able to participate in the planning. The sooner the planning starts, the more they're able to participate and retain some level of control over what happens to them in the future. Now, there comes a time, however, when cognitive capacity is sufficiently diminished that a person is no longer able to participate. So when I visited Ruth out at the assisted living facility, it did not appear to me that she had legal cognitive capacity. She didn't remember who I was. She seemed confused. She didn't seem to hear or understand me when I spoke to her. If a person doesn't have a will, the state law has a will for them. And there are two forms of the state law wills that you have if you don't have your own will. they're called, one is called a will substitute, and the other is called the law of intestacy. Now, a will substitute avoids probate, and it takes priority over a will. An example would be a joint tenancy. If you have a joint tenancy account or a joint tenancy real estate with another person, when you pass on, it goes to the other person who's the joint tenant without going through probate, and it takes priority over what a will might say. A joint tenancy is a will substitute, as is a payable on death account. A payable on death account is an account that you might have with a bank in which you've designated another person to be an agent, or you can have an agency account. But a payable on death account is one where you have a payable on death designation with the bank, so that upon your death, it's payable to another person. That bypasses probate. And of course, beneficiary designations on such things such as an IRA, life insurance, a pension plan. The beneficiary gets the assets, gets the life insurance without it going through probate. And then a very popular will substitute is a revocable living trust, where a person puts assets in the trust, and those assets then do not go through probate when the person passes on. Now, if a person doesn't have any of these will substitute forms, like a joint tenancy, a payable on death account, revocable trust, then the state law has what's called the law of intestacy. That's where the legislature has decided what they think is probably what most people would want to have done if they die without a will. And the law of intestacy would then determine who gets your assets without a will. Now, if there's no power of attorney, and if there's no trust, then it becomes necessary for the court to appoint a conservator to manage or protect your assets. That is what I thought had to be done for Ruth. When I came back to my office after visiting with Ruth, I thought that was probably the only option, is to have maybe a conservatorship established for her. Now, an advance directive is a combination of a power of attorney for medical care and a living will for end-of-life decisions. What level of life support do you want at the end of your life? If you cannot communicate your preferences at that time, well, that's what you put into the advanced healthcare directive. And I'm going to talk a little bit more about that later. But if a crisis occurs and you and your family are not prepared, you face confusion, uncertainty, and panic. It's kind of like being on the freeway. You're late for an appointment, the GPS goes out, the directions are in the trunk, and you don't know which exit to take. So you enter into what we call the long-term care maze. And that is basically what Lori went through some 20 years ago with her parents.
Yes, I went through this personally. As Kathy also said, my mother suffered a stroke that left her disabled on the right side of her body. And I, being a good daughter, thought, I'll bring her home after rehab. We'll take care of her at home. I was totally unprepared for what I was going to need to do. I was confused, and I was cast into the long-term care maze almost immediately. I had a very, very difficult first month, disastrous in some ways, trying to care for my mom full-time, as well as caring for our 3-year-old and my household and my business. I became extremely ill. I was overwhelmed, stressed to the max, and at that point it dawned on me, I need help. Didn't want to ask for help, but I needed help. And many of you can probably relate to this. You may have been through this yourself. But where does a person start? Where do you get help? How do you know where to turn? How do you know what you should pay for it? How do you pick a caregiver and know that they're going to be reliable? Well, we're here to say to you, start thinking about these things early. Prepare early as possible, so that the loved one that you're caring for, if possible, can participate in this and can express their wishes. This will help reduce the anxiety and the fear of not knowing who to turn to or where to go. Start thinking about these major decisions. First off, who's going to care for your loved one? Be realistic about this. How is care going to be paid for? There's going to need to be a review of finances. And who is going to make decisions for your loved one on the financial side and on the medical side when they're no longer able to make them themselves? We want to urge you to, in your early planning, to get help from a team of advisors and navigators. Assemble this team early and include an elder law attorney who can document your loved one's wishes and assist the family with solutions to estate planning and financial problems that may come up. In addition, consider retaining an elder care coordinator. This might be a nurse or a social worker who is well acquainted with the resources in your community and has experience working with older people. They can help focus on getting that person the right care from reputable care providers. If you're unfamiliar with what an elder care coordinator is, I want to tell you a little bit about our elder care coordinator and the role she plays with our clients and some of the stories that'll help you understand how important this role is in the care of your loved one. The first thing that an elder care coordinator will do is conduct a home assessment. This is done in the home, and in the case of our ECC, as we call her, it includes not only a review of health and capacity, but also environment. Where is the person living and what is the environment like? Do they have an opportunity for social stimulation and engagement with others? Are we talking about a widow all alone in her home who never goes out and only sees the mailman once or twice a week? Or are we talking about someone with a large church family that visits regularly and makes sure that that person is okay? She's also looking at family dynamics. How does the family work to support the elder? Are there any dysfunctional family members that we need to be aware of? All of this is part of the quality of life assessment. And as I said, it's important it be done in the home. To underscore this, I want to tell you a little bit about a lady that we represented last year who has since passed on. Our elder care coordinator went out to see her to conduct a quality of life assessment. This is a single lady, no children, and no family nearby. First thing she noticed were very steep steps leading up to the front door with no guardrail, no handrail to grab onto. And when she went into the home, there was clutter everywhere, stacks of things all over the floor, and an arcing electrical cable in the kitchen tied up on the ceiling. Very unsafe situation for this lady. The clutter was so bad on her bed that she was actually sleeping on the floor next to her bed instead of in her bed. And there was barely any fresh food in the refrigerator. Very unsafe environment. In cases like this, what follows from this home assessment are recommendations for community and technological resources. In this lady's case, the recommendation, as you can probably guess, is that she be moved into a safer environment, into a memory care unit at an assisted living community to safeguard her. However, until that could be arranged, technology could be used for a short term, even something as basic as a life alert type of device, personal emergency system, so that in case she fell or had an emergency, she would be tied to a dispatcher who could send help. These things all contribute to quality of life. And part of the follow-up to the assessment is getting medical records from doctors, getting care plans from care facilities, and understanding what the medications are that the person takes. This became a critical element with a client that we currently have, who it turns out had 2 blood pressure medications prescribed by the primary care doctor, 2 other blood pressure medications prescribed by the cardiologist. Neither doctor knew the other had prescribed these medications. And the adult, not knowing that there was a duplication here, was filling the medication boxes, the pill boxes for his dad, with 4 different blood pressure medications in what could have been a near fatal dose. It is because the elder care coordinator reviewed the medications, uncovered the problems, and put a halt to all of this that the man is still alive today. Another important role of the elder care coordinator is helping to educate the family. We have a great many clients who have got some form of dementia. They may have Alzheimer's, they may have vascular dementia from a history of strokes, Lewy body. We've had folks with Parkinson's who have a related dementia. And families really need to understand the underlying disease, how it affects the brain.
Dorothy.
Because without this understanding, they can't know how to communicate with their loved one effectively. There are very well-studied techniques that can help families communicate with their loved ones without the loved one feeling diminished or disrespected. But it takes patience and it takes some education for families to practice and understand that they need to change because their loved one is no longer capable of changing. Beyond this, an important role of the elder care coordinator is to advocate for the client. And this may take place in the hospital, it may take place in care homes, it may take place even with the family. In the hospital setting, it becomes important because oftentimes a hospitalization is followed by a period of rehabilitation in a nursing home. And if the person was not admitted to the hospital, if they were instead considered under observation, then the cost of the rehab will be covered by Medicare if they were admitted, won't be covered by Medicare if they were under observation. It's an important difference in status. And if a person is under observation, they may be at the hospital for several days. They may be in a room. It may seem as if they must have been admitted. They could still be under observation. And an elder care coordinator that can go in, find out the status, speak to the client's personal physician, and see what can be done to change that status could save them, the client, thousands of dollars. There's also a need to educate and to advocate in care homes. A lot of people think that once a loved one is in a care home, in a nursing home or an assisted living or even foster home, that they're taken care of, they're in a safe place. I don't have to worry about them anymore. But this is often not the case. And when the problems crop up, the family often feels reluctant, hesitant, and unprepared to address the problem because they worry that if they complain, it may affect the quality of their loved one's care. We had a situation a few years ago with a dear lady named Sally who had dementia, was in an assisted living community that had a memory care facility. And she had a new roommate move in with her, who unfortunately in the middle of the night would get up and urinate on the carpet thinking she was in the bathroom. And our ECC went in to see Sally one day and was stopped at the door by the smell of the room. Immediately knew there was an issue. Apparently the rug, the carpeting had been shampooed, but the smell remained. And it took some gentle but firm advocacy to get Sally moved out of there and into a clean room. It was done without affecting the relationship between the family and the facility. Sometimes this is also important with family members. We've had situations where a mom and dad hire us to help because dad has dementia and mom is 90 and is running out of steam trying to be the caregiver. But the adult children are so involved in their own lives that they don't really recognize that there's a problem. We've heard them say to us, it's not that bad. And it has taken the advocacy of an elder care coordinator to help them understand that if mom hired us, there must be a problem. We need to all be on the same team to address it. So as we've talked about, the elder care coordinator does a lot of education. We're talking about offering options for living arrangements depending upon the care needs, possible sources of caregivers from vetted agencies, other resources that may be available like visiting nurses, home health, electronic monitoring that may be available. There's a lot of education that has to happen. And I want to say that a lot of the education has to start with giving folks an understanding of the cost of aging in place versus the cost of moving to an assisted living facility. Because again, there is a misunderstanding where people think it's cheaper to stay home, not understanding that safety is the main issue. And if modifications aren't made, that it could result in a fall that could cause a decline, an early decline. So that is a huge part of the educational element. And then finally, moving forward, the ECC is monitoring care over time, assisting with problem solving, helping the family make good decisions. And this is through regular quarterly meetings, in-face meetings, and seeing the families and the clients whenever there is a problem, even if it's in between. We have an elder care coordinator who has persistently been working with a niece caring for or in charge of the care of her older auntie, yet another older lady, widowed, living alone in her own home with dementia. When it became apparent that there was moldy food in the refrigerator and that this lady did not have the ability to discern that it needed to be thrown out, it became apparent that a move was going to be necessary. And so our ECC has been working with the niece for some time, helping her understand how important it is that auntie's safety be uppermost in her mind. And my understanding is that she is very soon going to be moved now into a very good assisted living situation on the windward side with memory care.
And that, of course, raises the next issue, which is trying to figure out how you're going to pay for care. Memory care can be quite expensive. Remember Ruth? That's what generated the call to my office. The assisted living facility wanted a method by which they would get paid for their services. Her agent under the power of attorney was no longer available. There was no alternate named under the power of attorney, and she lacked the capacity to pay her own bills. So we had just hired, this was about 5 years ago, 6 years ago, we had just hired our first elder care coordinator. This was a nurse named Sue. So I got back to the office, talked to Sue. She said she was going to, she told me she'd go out and visit with Ruth, and she would talk to the care providers out at the assisted living facility, and she would talk to the primary care physician. We'll tell you later what came of that. But we recommend that you create, first of all, a long-term care fund. And there's possible options for preparing that, for creating that fund. The first would be a cash reserve. Now, a cash reserve could be a joint bank account with a trusted child, or you could name a child as an agent on that account with the bank, either a joint bank account or an agency account. Now, the purpose is to pay bills. Now, this may be funded with maybe up to 6 months worth of anticipated bills and is kept available in the event of an emergency. You've got somebody that is right there available to pay bills in the event of an emergency. Now, one thing to keep in mind, however, is a joint account doesn't terminate at death. So it can be used to pay for the funeral. It can also pay bills after a person passes on until a death certificate is obtained, which could be, 2 or 3 months after death. In our current environment, it's taken even longer to get the death certificate out. Now, an agency account, on the other hand, gives the child the ability to pay the bills, but that terminates at death. And so there would then be a delay between the date of death and the availability of a child to be able to then continue on to make payments, such as getting the death certificate, so that a revocable trust could be actuated. So cash reserve account is one option. Another option would be to have a reverse mortgage. I have a reverse mortgage. It sits dormant for now, so there's no interest accumulating on it, but I can draw on the equity of my home for emergencies or for long-term care. So it's a backup plan for me. Hopefully I'll never need to use it, but it's there available. Many people have purchased long-term care insurance. If you have a long-term care insurance policy, be sure you understand when it kicks in. One of the first things we do when we're hired by a client is, if they have a long-term care policy, is to immediately review that policy to make sure that the client as well as us understands when it kicks in. We had a client recently, we reviewed the plan and found that he had missed 2 years worth of coverage for his disabled wife. That's 2 years of plan payments lost. Another possible option is what we call a parental protection trust. This is a more complex type of planning, but if you or your loved one is insurable, one idea is to have the children purchase a substantial life insurance policy on the parent with a long-term care indemnity rider. Now, the policy is placed by the children into a special needs trust with the parent as the beneficiary. If the parent becomes disabled, the supplemental needs trust can collect on the policy. The money collected does not disqualify the parent from Medicaid and can be used to supplement the parent's care at the nursing home, such as providing for a private room or hiring a personal care attendant. When the parent dies, the proceeds of the policy, or what is left after the long-term care, is payable then back to the children. So you should hire an elder law attorney to help you organize, customize, and update your legal documents. One of those legal documents that is important to have is a power of attorney. In 2014, which is just 6 years ago, the Hawaii legislature adopted the Uniform Power of Attorney Act. It substantially changed the authorities and provisions under the power of attorney. And so if your power of attorney was done before 2014, you should definitely have it brought up to date under the new Uniform Power of Attorney Act. And in the course of updating your power of attorney, you should review the selection of your agent. This should be reviewed periodically. Is the agent still available? Or is the agent stable? Or is the agent financially competent and able to handle the financial affairs if they're called upon to do so if you become incapacitated? And you want to be sure to name an alternate agent. Wish that had been done in Ruth's case. We wouldn't have had the problem. Name an alternate agent in case the original agent is unable to serve, and then have certain enhanced provisions included that are specially designed by the elder law attorney for seniors. And in order to maintain Medicaid qualification and provide flexibility for the later years. And then have a provision requiring that the agent account to other family members. This is very important to help safeguard the possibility of exploitation. Now, the Advanced Healthcare Directive. The Advanced Healthcare Directive, we often supplement the Advanced Healthcare Directive with additional documentation that will set out a client's wishes under specific circumstances, what they want their end of life to look like. You may have heard of a document called 5 Wishes. That kind of supplements a Advanced Healthcare Directive. We use a quality of life statement. We also use a document that is very thorough in helping the client and the client's agent think through what would be the best end of life situation. It's a form we got from the mainland. I don't know if you can see it there effectively. It's called Your Way. And you can actually get this free. I can give you the website. If you've got a pencil, you could write it down, www.help, H-E-L-P, for the numeric 4, seniors, SRS.org, www.helpforsrs.org. You can contact them. You can go on the website. They can send you one of these for free. Another document that should be in place besides the power of attorney and the Advanced Healthcare Directive is the Revocable Living Trust. The purpose of a revocable living trust is to be able to manage your assets if you become incapacitated and to avoid probated death. When you do your revocable trust, you want to expand the incapacity clause to spell out more clearly the authority of the trustee to provide you with a higher level of care if you become incapacitated. For example, if you want to be stay at home and age in place at home, you should spell that out, and you should give the trustee authority to make adaptive modifications, to hire caregivers and other support personnel to come into the home. If, on the other hand, it becomes necessary for you to reside in an assisted living facility, in a foster home, or a nursing home, you may want to include in the trust authority for the trustee to pay for a private room instead of a shared room, to be able to hire a personal care attendant to supplement the kind of care that is being provided by the nursing home. All of these are designed to improve the quality and of care that you receive in assisted living or in the nursing home. Your attorney should also provide an ongoing maintenance program for your estate plan. Now, had Ruth been part of a maintenance program, 10 years would not have gone by without us keeping in touch. We'd be in touch on a regular basis, at least annually, and oftentimes more frequently. A maintenance program involves regularly monitoring the estate plan and the finances. We want to make sure that, first of all, we know what the assets are so that accounts can be easily located in the event of a crisis. The children from the mainland call and say, mom's in the hospital, and we don't know who has a power of attorney, and we don't know where her accounts are, and we don't really know anything about her financial situation, and we're flying out, and you're the lawyer. Can you help us solve this and help us walk through what needs to be done? And I don't want to have to respond, well, gee, I haven't talked to your mother in 15 years. I want to be able to say, yes, I met with her 3 months ago. I met with her 6 months ago. I know exactly where the assets are. I know exactly who has the power of attorney. Come on out and we'll get to work on this. If there's a revocable trust, we want to make sure that the trust is fully funded. That's a big problem with the revocable trust. Sometimes you see these ads that say why a trust doesn't work. Well, the reason a trust doesn't work is it hasn't been funded. The person sets up the trust, they go home, they put it on the shelf, and they never get around to putting their bank accounts, their investment accounts, the life insurance beneficiary, and all of that stuff into the trust. So we want to make sure that gets done. We want to make sure that the beneficiary designations on the IRAs, on the pension plans, and on the insurance are consistent with the estate plan. If the trust says, upon my death, divide equally between my 3 children, but it turns out that the insurance is payable to a sister or to somebody else, and the beneficiary changes were never made when the trust was set up, we need to get all of those beneficiary designations and bring them up to date. We want to make sure that an emergency fund is in place, such as we talked about earlier, maybe a cash reserve fund or a reverse mortgage. We want to make sure that all the legal documents are kept up to date. And we want to make sure that the agents under the power of attorney and the advanced healthcare directive are available, are capable, and know what they're supposed to do. We have a whole documentation to help the agent know what happens in the event of an emergency, what their job is as an agent under a advanced healthcare directive or under a power of attorney. You should evaluate the possibility that you or your loved one might need Medicaid assistance in the future. And there's some things you can do to plan for it. One is a rather complex document called a Medicaid Asset Protection Trust. And the purpose of that is to transfer assets that would otherwise disqualify a person from Medicaid off the Medicaid radar, but still be available to the family for the care of, for your care. Another possibility is transferring assets from the spouse who is in the nursing home to the will spouse, the community spouse, the spouse that is at home. The will spouse can then provide in her will that if she dies first before the institutionalized spouse, the assets, instead of going to the institutionalized spouse and disqualifying him from Medicaid, the assets instead will be distributed into a supplemental needs trust for the nursing home spouse, and then be available to enhance the quality of care of the nursing home spouse without disqualifying him or her from Medicaid. So those are some of the things that we can do for planning.
So we've just covered all of the important issues your team of advisors can help guide you through. But now let's talk about things that you can do yourself to prepare for potential incapacity. One of the first things that needs to be done is you need to have a family meeting and start a conversation about what matters most in your loved one's life. To the extent that you can include them in this conversation, you should. If not, talk to them separately and share it with your family. What's most important to them? Is it being at home with family? Is it not being alone? Or maybe it's rather, well, they're concerned about being a burden on the family. Talk to them. Gently discover what brings them joy in their life. Perhaps it's seeing their grandchildren every Sunday, or spending time with their dog, or sitting out in the garden listening to music. Talk about that. Find out what it is so that you can help them experience that as time goes on. And as Tom has said, discuss who's going to be the agent for the finances and the medical decisions, and make sure that that person is responsible and well suited for that job, and that they will help to carry out what needs to be done moving forward. And then finally, talk about realistically who's going to participate in being a caregiver. Keep in mind that everyone can contribute in some way to being a caregiver, so that it doesn't all fall on one person's shoulders. Unfortunately, that is often the case. But I want to tell you really quickly, we have a colleague in the insurance industry, a professional who does his mother-in-law's laundry every week. That is his way of contributing to her ongoing care. It's not beneath him to do it. He does it gladly. And other family members drop by with food a couple of times a week. Some people are in charge of picking up prescriptions or picking up groceries. There are lots of ways the family members can contribute. They just need to be asked. Sometimes we use a sign-up sheet with all the different tasks on it and circulate it among family members to help them realize.
Lil, Lori, you went on mute. Lori? Lori?
Let's see if I can find her here.
Lori, you went on mute. We lost you.
Lori?
Okay, there we go.
Okay,
Sorry.
you're back on.
I just suddenly, I think I was clicking the PowerPoint and I suddenly muted myself. I apologize. So for those who are what we call solo agers, who don't have family nearby on the island, there are professional fiduciaries that can, who can take these roles on as financial agent, medical agent, but you need to interview them early, find the right fit, find the right person, meet them annually, make sure that you build a relationship with them, that they have the opportunity to get to know your loved one so that they can make decisions that align with their priorities, with your loved one's priorities. Create a caregiver backup plan. This is the #1 most neglected item on the list. And this seriously puts your elder at risk because, as we've said over and over, you can't depend upon one person alone to do the job. It's simply not sustainable. And if that person becomes ill, passes away, you're going to be left in the lurch. It's very well documented that full-time caregivers are at high risk of becoming ill and sometimes even passing away prior to the one they're caring for because of the stress and the demands of the job. So create a backup plan. Create a medical inventory. This could be a 3-ring binder. It could be inventory, a medical inventory app on your smartphone, but create something that will give easy access to things like summaries of medical visits, list of doctors and contact information, list of caregivers, medications, dosages, pharmacy phone numbers, copies of insurance cards like the Medicare cards. Make sure you get both sides, front and back. And if there is long-term care insurance, might be a good idea to have a copy of the annual benefit statement available in that binder so that it's top of mind. And when the person qualifies for long-term care insurance, you won't forget to make the claim and initiate it. By the same token, consider preparing a financial inventory, another binder or another section of the binder, and create a list of assets with those copies of those bank statements so that somebody stepping into your shoes would know right away where the accounts are, what property is owned, what the potential credit card, mortgage, monthly payments are, what the income is coming in, regular expenses, all of that. If there is a concern that at some point in the future, government assistance may be needed to help pay for care via the Medicaid long-term care program or the Veterans Administration aid and attendance benefit for wartime veterans and surviving spouses, then start keeping the records that you're going to be required to provide when you apply. For the Medicaid application, they have the right to request records going back 5 years. It doesn't often happen that you're asked for that, but it couldn't hurt now to start accumulating those bank statements, all of those records in advance so that when it's needed, you won't be scrambling to find things. These are the kinds of things you want to put together. The financial accounts may be the hardest to obtain later if you put it off, but obviously you're going to need things like birth certificates, social security cards, and the DD-214 discharge papers for the Veterans Administration. It could be very helpful to family members later on when you apply. If your loved one has any digital accounts, perhaps they have a Facebook page or they have an email account. Maybe they've done online banking. Create a list of passwords and account numbers and pass that on to their financial agent with a instructions on what should be done with these accounts should they become incapacitated or after they pass away. And it's obvious this information needs to be safeguarded, put in a safe place, but the agent should know how to access it when the time comes. So what are the benefits of all this preparation? Well, you will have greatly reduced the anxiety and fear that can overcome all of us when a loved one is incapacitated. And we consider this just an amazing gift you can give your family for the future. If you've done all this early planning, you've got all your ducks lined up, then your team of advisors will be able to step right in and immediately help in an emergency. They can jump right in a crisis to help you, to help your loved one, and help reduce the anxiety that comes with the crisis.
Let me jump in right now, maybe to give you an update on, remember Ruth? Well, here's the rest of the story. Our elder care coordinator went out to visit Ruth at the assisted living facility. She reviewed Ruth's medications and thought she was being over-medicated for a lifelong epilepsy problem. She talked with the PCP and he redid her meds. She also found that no one had thought of changing the batteries on Ruth's hearing aids. I went back about a month later to visit with Ruth, and when I came in, she said, well, Tom, it's been many years. How are your daughters? Ruth had cognitive capacity, and we were able to redo her power of attorney. The problem wasn't dementia. The problem was over-medication. Now, we were also able to move her to an ARCH, an adult residential care home in Pearl City, where there were 5 other ladies of about the same age with whom she bonded, and at $6,000 a month rather than $10,000 a month. So being prepared averts the disaster.
Right. And if you take anything away from all of this talk, please take away the idea that preparing early is what needs to be done now. Give some thought into bringing in a team of advisors to help you make those preparations so that you're being proactive and not reactive. Now, if there are questions, we'll take a look in the chat box. I'm going to stop sharing this PowerPoint. You can always email me at the email address on the screen if there's something you'd like to ask privately. But let me stop sharing and then we can see if there are any questions.
Lori, we have 1,000 questions. They're very good questions. So I'll start reading them and you answer, okay?
Okay.
Someone wants you to explain revocable versus irrevocable trusts.
A revocable trust is one that you can change while you're still alive. When you die, of course, you can no longer change it, so it then becomes irrevocable. But while you're alive, most of the trusts that people do are revocable because you can make changes to it, you can amend it. However, sometimes a person will, while they're alive, set up an irrevocable trust to hold life insurance or to provide a special needs trust for a handicapped child or some other form. An irrevocable trust is one that you can no longer make changes in and are done in certain cases for tax purposes. It's a big topic, but that's kind of a short answer for it.
Okay, the next question is a will substitute applicable to real estate? I thought a trust was the only way to keep real estate out of probate, no matter how the title is held.
No, Hawaii has adopted, well, you could have jointly, of course, jointly held real estate doesn't go through probate. Husband and wife often hold their real estate as tenants by the entirety. When one dies, it automatically goes to the other. If you put your kids' names on as joint owners, when you die, it goes to them without going through probate. But Hawaii has adopted a new law relatively recently, within the last several years, called a revocable transfer on death deed. Where you can actually have a deed prepared and recorded at the Bureau of Conveyances, which transfers the property upon your death to the named beneficiary on the deed. and it can be revoked at any time. And this was the Hawaii legislature's response when they saw so many people setting up trusts to avoid probate of real estate. Well, they devised a way of having a transfer on death deed to avoid probate of real estate. So that's another option.
Okay. Why does the elderly need a POLST, life support guidance?
A POLST it's short for a physician ordered life support, and it is actually signed by the doctor after interviewing his patient, who is at that point in time determined to be close to the end of their life, generally in a terminal illness, or it is generally thought if in 6 months' time chances are they won't be there. It's different from an advanced healthcare directive that everyone should have, because a POLST is a physician order. It's used by EMS when 911 is called. They use that to determine whether or not they're going to be providing full-on life support care on the way to the hospital, or whether they're going to be just transporting without that level of care.
Yeah, it's a do not resuscitate order. So if a person stops breathing, it's an instructions not to perform CPR to bring them back.
Right. Next question, are there elder law attorneys and care coordinators on Hawaii Island?
On the Big Island, there are elder law attorneys on the Big Island. I don't know about, I think there are care coordinators that are available on the Big Island as well. I know Bonnie with Hau'oli, I think she goes outer island as an elder care coordinator.
I think for the most part, you might be looking for somebody that might go under the title of a geriatric care manager. And there are some agencies that have geriatric care managers that are RNs that can work in the role of an elder care coordinator.
Okay. And let's go ahead and plug Kim here. Kim Ong, I sent that when I sent you the bio for the company. Kim Ong is listed, and she is the certified elder care coordinator that works with Lori and Tim. So I just want to put that in.
Right.
Yeah.
Right.
Okay. Next
She's
question.
on staff with us. Mm-hmm.
Yeah. Where do you find a care coordinator for quality of life assessment? Okay.
Well, it's pretty much as I just said. We look for home health agencies that have care coordinators, have RNs. There are a few geriatric care managers that work apart from agencies. They are in high demand, and there's no one organization that you can turn to, because some are social workers and some are RNs.
Okay.
I suppose if you Googled geriatric care manager or elder care coordinator, you would come up with probably a list of maybe some that are local.
Okay. With elders that have both with both partners, are assessments done as individuals or together?
It kind of depends. If one is healthy and the other is not, we might do just the assessment for one, although sometimes a husband and wife will want us to do the assessment for both, in which case we combine it, but it can be done either way.
Okay. Once declared incapacitated by the courts and placed under guardianship, how much weight does the guardian place on the ward's wishes and let me start over, sorry. Once declared incapacitated by the courts and placed under guardianship, how much weight does the guardian place on the ward's wishes and requests? The order of guardianship states to continue to honor the ward's wishes.
Well, the guardian is supposed to honor the ward's wishes. That's their function. But we try to avoid guardianships altogether. If you have a well-drafted power of attorney, then there's oftentimes never a need for a guardianship. A guardianship or a conservatorship happens when you haven't prepared and you don't have a power of attorney. That's what we thought we were going to have to do for Ruth until we were determined that she did have cognitive capacity and was able to do a new power of attorney. But but as far as the question goes, the guardian is supposed to look to what the principal's wishes were with best as they can. And oftentimes that's where the Your Way document that I showed earlier becomes very helpful to the guardian in seeing what the express wishes of the individual were for care.
Okay. We are both competent and physically active, but we can tell we are physically declining. How soon do we engage an elder care coordinator?
You do it right away. You should have, in fact, what we did is we focused initially on just persons who were already had chronic illnesses or cognitive deficiency. And then I had clients, I've been doing this for many years, and I've had clients call me and say, well, Tom, I'm independent and I'm still active, but I want to be prepared. And I'd say, well, we're just kind of working with our chronically ill clients. And they say, in other words, you're firing me. I said, no, wait a minute. We've had a relationship for a long time. So we developed a process with our firm of doing what we call limited life care planning. We do a lot of preparation to help the client get fully prepared in the event of incapacity. And so we we review all the estate planning documents. We do an initial medical kind of capacity assessment to get a baseline. And then we do a lot of preparation for in the event of long-term care to be ready for it. So we do kind of a limited life care planning. And I think probably if you're in your 70s or 80s and you're still independent, and you want to be prepared, this is something that you might consider.
And the elder care coordinator, for these older folks who are really healthy and independent, there's a very limited involvement by the elder care coordinator because they don't need to see somebody on a regular basis until their situation changes.
And I just wanted to bring up, having a nurse on staff for us has made all the difference in the world. I would meet with my elderly clients and we would do estate planning and revisions and so forth. And I would say, boy, they seem fine to me. Looks okay to me. And in one case, our Kim was in there and she didn't say anything, but as soon as the clients left, I said, well, they seem like they're, perfectly fine to me. And she says, Tom, are you kidding me? Did you see her hair? Did you see his feet? I was afraid he was going to have a coronary event, before he got out to the car. Did you? And she with her eye as a medical person, she was able to spot all sorts of things that, I don't know. I'm a lawyer. I don't have that medical kind of knowledge. So it was really helpful for us to keep us informed and to inform us on the medical capabilities of our clients so that we could do a more thorough, comprehensive job for them.
So it's the medical legal partnership, the team of medical and legal together is far more effective than having people working separately under different umbrellas who aren't necessarily talking to one another.
Mm-hmm.
Next question, can I ask my medical insurance company for a care coordinator?
I don't know whether it would be covered. I can tell you that under a lot of long-term care insurance policies, there is a provision for a care coordinator, oftentimes provided at no cost. They will help guide you through the long-term care maze. But with regular medical insurance, it's rarely a benefit.
Okay. What is the fee for getting this assessment in elder care coordinator?
We was going to say, we don't really break things out individually because the planning that we do is an ongoing program undertaken a year at a time, and it includes a whole host of other services. So we don't have a standalone fee for an elder care coordinator or an assessment, or for that matter, a standalone fee for a legal document.
One elder care coordinator that I'm familiar with in Hawaii, though, does have an initial assessment fee of about $400 to $500, and then maybe an annual fee that would amount to maybe $4,000 a year to $5,000 a year for continuing oversight and care.
Mm-hmm.
That's about what you look for.
I'm sorry. This question's been asked a couple times, but I'm going to let you answer it one more time. How does one find an elder care coordinator?
I would say you could Google.
Okay, Google, okay.
Look for a geriatric care manager or elder care coordinator. Um, uh, I don't know that we still have. Do we still have yellow pages in the phone book?
We have yellow pages online.
Online, yeah.
But be aware that care coordinators, some care coordinators are devoted to disabled children. There are care coordinators for different segments of the population. And what you're looking for is an elder care coordinator or a geriatric care coordinator or a geriatric care manager. Somebody who is familiar with resources that serve an older adult population.
Mhm.
All right, before I read this next question, I'm going to tell you that I am the mother in this question.
Okay.
I think I told you this before, Lori. My daughter and my sister have been asking me for 2 years now to, do I have an advance directive and blah, 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 blah. And my answer is, I'm working on it. I'm working on it. I can remember when my mom and dad started talking to us about their advance directives and stuff like that. I could not stand hearing about it because I didn't want to think that my mom and dad would ever leave us.
Right.
Mhm.
So now I'm in denial and I'm still procrastinating, but I'm working on it. So the question is, how do I get my mother to engage in her future plans? She shuts down and will not participate.
We try to help folks realize that if they want to maintain control, the best way to do it is to document their wishes so that if at some point in the future they have to rely upon others to carry out their wishes, at least their wishes, they know what they are, they've been documented. And by documenting it and having a trusted person carry them out, they are still in control. If they don't do that, they have lost control because now somebody else is making decisions about their life without their input.
One of the questions we ask clients when it may be an initial type interview is, what's important to you? Why are you visiting us? What's a major concern? And one of the answers we hear quite frequently is, well, I just don't want to be a burden on my children.
Yeah.
And we tell them, one way of not being a burden on your children is to prepare in advance so that they're not left like that car on the freeway in panic and confusion, not knowing which way to turn, not knowing where the assets are, not knowing what's, who's in, what's going on. And so to avoid being a burden on your children, be prepared. And in being prepared, you can more often retain control and independence for a much longer period of time than if you're not prepared.
Okay, now I feel guilty. Thank you very much. Okay, threshold for capacity has very low standards. What can I do if my loved one is diagnosed at the mild level, but driving is an issue and he or she refuses to stop driving? Loved one has gotten into several unexplainable accidents with his or her car. And I can jump in here for a second on this. When we teach caregivers about dealing with the dementia, one of the things is give them different keys or disable something on their car that can't,
Yes.
just say the car's broken down, we have to take it to the shop and sort of divert that way. But go ahead, I'm
Right.
sorry.
We've used the same advice at times. The car needs to go in for work, and because there is a cognitive impairment, often they don't remember that the car has been in the shop for 6 months now. So, that can be repeated. The car is in the shop and it's going to be repaired, and you just kind of leave it in limbo. That's called
Therapeutic fibbing.
Therapeutic fibbing. And there's nothing unethical about it. It is basically not providing the loved one with more information than they have the capacity to process, and not providing them with information that is going to cause an emotional upset. So if you get into over and over, you get into a big debate about you need to stop driving, I'm going to take the keys away, and so on and so forth, you can predict that there's going to be pushback and there's going to be emotional upset. If you can wrap your mind around the idea that this is actually a better way to communicate with them by therapeutic fibbing. The car is in the shop, and we're going to have to wait till it gets fixed. It's going to keep them in a much better emotional place.
And there are some alternatives. There's the one with, I think Uber has come up with a alternative. What's that called, Lori? It's called.
Well, you have to have other transportation options available for them so that they don't suddenly feel like they're stuck at home. And ride sharing is a really great alternative. There is a Jitterbug smartphone you can purchase. It's not expensive, and it's intended for older people, and it's designed with a zero operator button. You can push. One button push will connect you to a Lyft operator who will set up your rideshare for you.
Oh.
You don't have to go online. You don't have to navigate a website. You just talk to this person, say, I'm at home. I need to go to church today. Can somebody come and pick me up? And they can set it all up and tell you that we'll have somebody there in half an hour. Of course, a family member has to go in and put the credit card online, set up the account, but it can reduce a lot of agitation over transportation when a person can no longer drive. If they can manage to press the 0 on the smartphone, they can be connected to a ride.
Okay, that's cool. Okay, we talked about the ballpark figure for charges for an elder care coordinator. It sounds like the family could be working with their ECC for a relatively long-term duration, maybe as long as the affected loved one is alive. That's
correct.
Okay.
That's correct, yes.
Okay. Any thoughts on how effective the care management program with Medicare is? PCPs now have an option of offering care management to their patients.
I can't really comment on that because we haven't seen that in action to any great extent. We really advocate for having somebody local who actually sees your loved one regularly, can monitor their condition, can help address their needs, as opposed to someone who may have a caseload of several hundred people, and it may not be as personalized as having a personal elder care coordinator looking out for you.
Who do you see regarding setting up a cash reserve? Do you go to the bank or an investment company such as Ameriprise?
You can do either. If it's generally going to be a small account, you're looking at maybe 6 months worth of bill paying. So you're putting maybe $20,000 or $30,000 in the account, and it could be just a bank account. Very simple.
Okay. Can the successor trustee take out a reverse mortgage or mortgage on behalf of the beneficiary to help pay for care?
It depends on the terms of the trust. If it's a trustee that's doing it, there has to be specific provisions in the trust agreement that authorizes the trustee to enter into one of these home equity conversion loans. And there's certain language that we recommend that be in the trust. Sometimes we put the same language in a will drafted power of attorney, so that if there's no trust, that the agent would have authority to sign on behalf of the principal for a reverse mortgage. So it can be done through either a power of attorney or a trust.
Okay. Repeat date of documents that should be reviewed.
Well, we're talking about the power of attorney, and the new Uniform Power of Attorney Act was adopted in Hawaii in 2014. So if your power of attorney is prior to 2014, you should have it brought up to date under the new Power of Attorney Act. Incidentally, people used to have problems with powers of attorney because banks wouldn't accept them if they were, more than 5 years old, and sometimes a brokerage firm wouldn't accept it unless it was signed within 90 days. We had that come up. And people used to have problems. They'd have a power of attorney and they'd go into the bank. The bank said, "Oh, our policy is not to accept powers of attorney." That was one of the things that the new Power of Attorney Act settled. If you have a power of attorney under the new Power of Attorney Act, if the bank refuses to accept it, you can provide them with an affidavit. And if they refuse to accept the affidavit and you have to go to court and get a court order, they have to pay your attorney's fee. So there's teeth put into the power of attorney under the new Power of Attorney Act. And so it's a good thing to have. And there's also a lot more provisions that are put into the statutory form that can be very, very helpful to elderly people in planning.
Okay, cool. Okay, so excuse me, how does a home equity line of credit work?
Well, a home equity line of credit that's a reverse mortgage. And basically it's, you have to be over 62, you have to own your home, and you take out a mortgage. Now what I did is I took out I didn't borrow any money with mine. I took out the home equity line of credit, but but let's say I wanted to get a payment of $4,000 a month. Well, I could arrange for that. Or if I wanted to get a lump sum, $100,000 or something, what they do is they take it out, they give me the money, but I don't have to pay it back until I either sell the home or die, or move out. So as long as I'm living in the home, I don't have to make any payments. Now, there are payments that are accruing. There's an interest on the loan that they gave me that accumulates in the loan. So let's say I have a house that's worth $800,000 and I borrow $200,000 against it. And the interest on that is 2 or 3% a year that's just accumulated inside the loan. I don't have to make payments while I'm living, but when I sell the house, or when I die, or when I move elsewhere, then what happens is the mortgage company will calculate how much I owe, the $200,000 that I borrowed plus the accumulated interest. That then gets paid back to the mortgage company, the reverse mortgage company, and the balance with it that's left over, the remaining $600,000 or $700,000, then goes to my family.
I just want to clarify, on the home equity line of credit, you do have a monthly payment. On the reverse mortgage line of credit, you do not have a monthly payment. There's no payment due, as Tom was saying, until after the property's transferred or somebody passes away.
Is the beneficiary designation on our investment accounts a substitute for placing the investments in our revocable trust?
I think it's an alternative. The best place to put your investments is in your revocable trust. And then in your revocable trust, you designate who the beneficiaries are going to be when you die. If you name a beneficiary as a payable on death or transfer on death beneficiary under an account, that would be like having 2 estate plans, having two trusts or 3 trusts or 4 trusts. It's better to consolidate everything under one document so that when you're making changes, you only make changes to the one document. And it also makes it consistent. Let's say, for example, you had a beneficiary designation for your daughter on the investment account, and then you had a trust that says, upon my death, divide everything equally between my 3 children. Well, the daughter's going to get 1/3 of the trust, plus she's going to get more than the other kids because she's going to inherit that investment account, which may create a problem if your goal is that everybody share equally, and now she's got a larger amount because she's both a beneficiary of the trust and a beneficiary of the account. So that might be a situation where you'd want to kind of consolidate the two, put the account under the trust so everybody ends up with an equal share. But there could be another situation where you want to leave a grandchild a certain amount, but everything else goes to the kids. But you want to designate a grandchild to get a certain amount, and you might name that grandchild as a beneficiary on the account. I think the better practice would be to name the grandchild as a beneficiary under the trust for whatever specific amount. Because I think a trust-centered estate plan should have everything pretty much consolidated in the trust, unless there are specific reasons why you would want to carve out something separate, like in a payable on death account for a particular individual.
Okay, I think this question was asked last week and it didn't get answered, so I'm glad that somebody asked it again. What criteria are there so a person can deduct expenses for caregiving? What can be deducted? What are qualifications that the caregiver must have to be able to deduct caregiving expenses and taxes?
It's a tax question, like they can deduct for income tax purposes. And I've got that information, but I don't have it on the top of my head. I know there are certain expenses that, depending on how it's drafted, that a caregiver can deduct, and there are certain expenses that they can't deduct. Or expenses that you're talking about the client being able to conduct for payments they make to the caregiver. Yeah, there are certain that are deductible and certain not. Oftentimes we're working with an accountant that
Makes
that
that
does
determination.
when they make
Yeah.
the tax return. But we do have information on that. I just don't have it on the top of my head.
Yeah.
Because we're
Would
not
they
asked that very often.
Would they have to be designated as a guardian in order to use that? Because they would be, oh, how do I want to put this? You know, they ask you if you're caring for somebody or you're the guardian of somebody and you are taking care of all of their business. I'll tell you what, whoever asked that question, please contact Lori and Tom on their email. Okay, we'll move on. Do we need to consider a supplemental needs trust if we have seemingly adequate long-term care insurance? And how do we find out?
Well, everybody's long-term care insurance is different depending upon how much the maximum benefit is, what the time period is, what the elimination period is when there is no coverage. The requirements differ by policy to policy, so it's kind of hard to generalize. And then whether or not you need a supplemental needs trust may depend upon the situation. If you've got a loved one in a nursing home and it's costing $15,000 a month because they've got complex care, and the long-term care insurance policy is only covering $3,000 a month, you've got a $9,000 shortfall, then you may find that you're going to run out of money, and you may need to do some Medicaid planning in advance, or supplemental needs trust to not disqualify the person from Medicaid when the time comes could be an advantage.
Yeah, so to put that into context of the example I gave, where you've got an institutionalized spouse, and let's say that spouse has got long-term care insurance, and that insurance is paying part of their cost of their institutional care. But they don't qualify for Medicaid because the community spouse, they have too many assets. Now the community spouse dies first. The community spouse of all the assets have been transferred to the community spouse, the will spouse, and then she dies first. And those assets are then distributed into a special needs trust for the benefit of the husband who's in the nursing home. Now the husband in the nursing home is still getting the long-term care insurance proceeds, and let's say that amounts to $2,000 or $3,000 a year, or $4,000 a year. The nursing home a month. The nursing home is charging $10,000 or $12,000 a month. So there's a shortfall. All the money that went into that special needs trust when the wife died first and is now in the special needs trust is not counted as a resource for the husband, even though it's available to augment his care at the nursing home. So now he's in poverty. All he's got is the long-term care insurance policy that's paying $3,000 a month. The difference can then be paid from the supplemental needs trust, the difference can then be paid by Medicaid. So Medicaid could then pay the difference, the $9,000 a month to the nursing home, and the supplemental needs trust money doesn't disqualify him and can be used to augment his care at the nursing home, to get him a private room, to get him a personal care attendant, to enhance the quality of his care.
And to pay for things that Medicaid doesn't pay for, like podiatry and dental care and all the rest of it.
Mm-hmm. So yeah, they too can be worked. Because you have long-term care insurance doesn't mean that the supplemental needs trust planning couldn't also be very, very beneficial.
My mom does not qualify for Medicaid, too many assets. Is a revocable trust the way to go should there be a need for long-term care?
No, revocable trust assets are considered owned by the individual who sets up the trust. If there's too many assets, whether they're in a revocable trust or not, will not change that situation. The trust assets are considered a resource.
What if the person you care for has no living relatives? What advice do you have regarding the issues you brought up regarding help with finances?
Well, sometimes there's a close family friend. Sometimes there's an individual that will be helpful, but there's also several organizations in town that, like the Caregiver Foundation with Gary Powell. I think he's appeared on some of your programs as well.
He's going to speak next Saturday.
Yeah, next Saturday, Gary Powell speaks. Well, Gary Powell's Caregiver Foundation might be an alternative. In fact, sometimes we've had clients that have no family members that are able to serve as a power of attorney or able to, you know, be put on an account for bill paying. And Gary can set that up through the Caregiver Foundation, which is a nonprofit foundation, but which does do bill paying, and he can serve as an agent under a power of attorney or as a trustee.
Can you explain a bit more about the transferring asset to will spouse supplementary?
Say that again.
Can you explain a bit more about the transferring asset to will spouse supplement probably? Yeah.
Let's say husband and wife own $1 million worth of assets. They have a home, they have some investments and savings, and husband becomes incapacitated and goes into a nursing home. We transfer all the assets out of his name into the will spouse's name. She's still okay. She's living at home. He's in the nursing home. They have too many assets to qualify for Medicaid. It's possible they could qualify depending on the equity of the home, and we'd have to look at whether or not we could provide maybe a Medicaid qualified annuity or something, and we can do some other planning. But let's say the end result is that you know, they're overqualified. Now all the assets are in her name. He's in the nursing home. She's paying private pay at the nursing home. She then dies before him. And she leaves those assets into a special needs trust for his benefit. Now he's in poverty. He doesn't own the assets in the special needs trust, and yet they're available for to supplement his care. So now he qualifies for Medicaid. And Medicaid will pay for his long-term care at the nursing home, and the supplemental needs trust can be used to supplement that care by giving him special additional things that Medicaid would not pay for. And then when he passes on, that supplemental needs trust terminates and distributes on to the kids.
Okay. Is there a list of professional fiduciaries available in Hawaii?
I don't know if there's a list, but we know of. Oh, go ahead, Lori.
Well, I was going to say there's estate administrative services, there's Hawaii Fiduciary Corp, the Caregiver Foundation.
There's Max Legal Services.
Max Legal Services.
And what is that?
CSI.
CSI, yeah, CSI that Shim is in charge of.
Care, support, and independence.
Yeah.
It's not the.
You mentioned the Caregiver Foundation. So
Caregiver Foundation.
Yeah, probably 4 or 5. Estate Administration Services, the Caregiver Foundation, CSI, Max Legal Services, Hawaii Fiduciary Services. That's Keller Holt's firm.
Right. Those are the top of mind.
And of course, there's then the professionals like, First Hawaiian Bank, Central Pacific Bank, and Bank of Hawaii. And some of the brokerage companies have fiduciary services like Morgan Stanley or Edward Jones.
The VA aid and attendance, do individuals who served need to have been in a war?
The VA aid and attendance they need to have served during a wartime, a specific named wartime according to the VA. World War II, Korean War, Vietnam War, and there are certain requirements that govern how much they are entitled to receive based upon income as well as medical expenses.
But they don't actually have to have been deployed to that war place. As long as it's during a time of war, they could be spend their entire service time on the mainland here in Hawaii and not actually
on a ship. We had one that was on a ship, you know, off the coast of Vietnam. We had another that was in the reserves here in the U.S., but trained to go off to war during Vietnam.
Okay. I missed the list of things to go into the medical inventory binder. Could you please repeat those?
Things like list of doctors and contact information, list of medications, dosing, pharmacy prescription numbers and contact information. Medications change, so that needs to be updated from time to time. And it also would be a good idea to keep track of the summary of visits that you get at the end of every appointment. It'd be a good place to keep that, so that if somebody needed to get up to date pretty quickly on health status, it would be available for them to review all in one place, as well as Medicare cards, long-term care insurance, benefit statements, that sort of thing.
It's a good place also to have your medical journal. So every time you have a visit with a doctor, you come back, you put the date and what happened. Just a short medical journal. So when 2 years later they ask you, did you get a shingle shot? You say, gee, I think I did. I'm not sure. Well, when was it? And you can look in your journal and you say, oh yeah, and you've got the date for it.
Okay. Please talk about the necessary steps that you need to talk to Social Security, as I understand the POA is not good.
Social Security wants you to fill out their form appointing a representative, and it may require, with the pandemic things are a little different now, but in the past it has required that there be a personal interview. The Social Security has their own rules, and so you're correct in that a power of attorney isn't necessarily going to open doors for you, but they do have their own process and their own forms, and you can work with them to get that filled out.
And you can actually go online and download the form from the Social Security.
Right.
Oh, that's good to know.
I think they may be doing telephone interviews now because they can't do in-person interviews.
Yeah. Okay, excuse me. Tom and Lori, thank you so much for this valuable information. Looking at the comments, I suspect I'm not the only one who has parents that are resistant to planning. Yeah. For years, my siblings and I have tried to have family meetings with our parents, but they are extremely resistant. We don't know whether their legal documents are up to date, they're not disclosing their financial situation, etc. And I'm pretty sure they're struggling with trying to organize all of these important papers. Thoughts on how to help them?
There's a book that we recently read called How to Talk to Seniors. And I would suggest you read that first. Really, it emphasizes the fact that for a lot of older adults, the first thing on their mind is holding on to control and independence. And there is resistance to giving to anybody inquiring about plans for the future, because there is the concern that they're going to take away my control and independence. They're going to start telling me what to do. Understanding the psychology that an older person, many older people go through is the first step. You can't force it. I will say that oftentimes bringing in third-party professionals as opposed to family members to introduce these topics and have these discussions in family meetings can be far more effective, because a resistant parent may hear the message differently coming from an attorney who works in this area than from the same message delivered by their oldest son, who they are concerned is, you know, he thinks that I'm incompetent. He's going to start making decisions for me.
Yeah.
I can give you a recent example. We had a gentleman that it was really not safe for him to continue to live at home. And the safest thing for him to do would be to move into an assisted living facility, like maybe the Plaza or One Kalakaua, or someplace where, but he was for years, for a couple of years, his children had been trying to talk him into, Dad, it's not safe for you to stay at home here. You should be in an assisted living place. And he just absolutely refused. I'm staying here. This is my home. I'm never going to leave here. This is my home. Well, we ended up getting hired, and our elder care coordinator went out and said, she saw this is not safe. And she explained the advantages of moving, and he says, I'm staying home. I'm going to stay at home. And so then we said, okay, that's your decision. We're going to advise you on how to make it as safe as possible. Here's our recommendations. And so we did a home review assessment. We recommended certain adaptive modifications of putting a door into the bedroom and escape place in case there's a fire. And so we said, if you want to stay at home, we're going to make it happen. And we're going to make sure you're safe here at home. And so we came up with this list of recommendations, and about 2 or 3 weeks later, the daughter called us and says, Dad's talking about moving to an assisted living. He says, I've been thinking about this, and I think this might be a good idea for me. And as soon as he realized he had the control of the decision, that somebody wasn't trying to talk him into something, that whatever decision he made, we were going to make sure it happened. And then it just opened up his mind. He was no longer in fear that somebody was trying to take control of his life. He was making the decision, and then he made a good, responsible decision.
But he had to. One case. He had to come to the idea that that he was making the decision that assisted living was a good idea, not that somebody else was suggesting it.
Yeah, it was his decision.
Okay. Please recap the list of team members that you talked about earlier.
Well, we talked about an elder law attorney, one that's familiar with the issues that an elderly person faces, not just a regular attorney, but an elder law attorney that knows the estate planning and long-term care insurance and those kinds of issues. And then an elder care coordinator, which could be a registered nurse, it could be a social worker, and an onboard family member.
Well, I also I want to add that the elder law attorney needs to be looking at the big picture. Our practice is very different because we're not traditional. We engage in what we call life care planning. It's a big picture, comprehensive type of planning, and you need to have somebody who is willing to look at not just estate planning, but financial issues and personal care issues, because they all end up intersecting, usually at the same time. So you need to have a plan that addresses all of it.
Yeah.
Okay. My dad has no financial assets. Most were used to pay for his medical, dental, health. Only my mom has financial assets. From what I understand, Medicaid counts both spouses together to see if they qualify. Since my mom's financial assets exceeds the maximum amount for my dad, while my dad has only his Social Security, which is under the Medicaid maximum amount, is there any way to get financial help for my parents at least for my dad?
Well, yes, even though mother's assets combined with what father's assets are, which he doesn't have any assets, even though the Medicaid looks at the combined source, the assets that are in excess of what the Medicaid required, minimum is that you have, the assets in excess could be allocated into a specially designed Medicaid qualified annuity that would then turn them from a countable asset into a non-countable asset. And there are that's just one possibility, but there are other approaches that an elder law attorney that practices in this field might come up with. For example, let's say a person had a home with a $200,000 mortgage, and they've got $200,000 in the bank. Well, they don't qualify for Medicaid because you can have the home, but you can't have more than $2,000 in the bank. So there's a kind of a simplistic solution. If they paid off the mortgage, they now qualify for Medicaid. They still own the asset. They've just moved it from a countable asset, a bank account, into a non-countable asset, the home. Or they purchase another home. There's all sorts of possibilities of planning where assets can be that are countable and disqualify you for Medicaid can be moved into a form that is not countable. Purchasing an automobile, for example. An automobile is an exempt asset. And it might be the good asset to have, especially an automobile that has maybe for transferring dad if he's in a wheelchair. Might be a van with a wheelchair lift or something. There might be a purchase of a funeral plan, which is an exempt asset. There are other exempt assets that could be purchased in order to qualify a person for Medicaid by moving some countable assets into what are called non-countable assets. And there's a whole list of things that could be done. And so I guess the bottom line is, yes, there's something that can be done, but you should visit with a knowledgeable elder law attorney that knows what those rules are and that can then help you make that planning so that dad could qualify for assistance for Medicaid.
Yeah, I just want to add that there is a community spouse resource allowance that is allowed because the Medicaid long-term care program is not intended to impoverish both husband and wife. If wife has assets, she's allowed to keep a certain level of assets. I believe the number is somewhere around 124,000 this year. It changes every year. So it's possible that it could be counted as part of her community spouse resource allowance. And then the excess used, as Tom said, to convert countable to non-countable assets.
Okay. There was another one about deducting expenses or caregiving that we already talked about. My mom has a geriatric physician. Can this physician have info on geriatric care coordinators?
I suppose he could. I don't know if
Possibly.
I don't know physicians that do employ care coordinators, but certainly they would be familiar with who's in the community and be able to make a recommendation for maybe an independent care coordinator.
Mm-hmm.
The next one is I've already updated my revocable living trust, advanced care directive, and durable power of attorney in 2018.
Mm-hmm.
Is there anything she should know about that?
Well, it's hard to say because not every revocable trust is equal. They don't all come off the same template, the same form. Each different attorney, depending upon the emphasis of his practice, may have a different format. I know for many years when most of my clients were young, my revocable trusts were designed for people that had young children, minor children. There are a lot of clauses that dealt with, protection trusts for children as they got older. I didn't think too much about elderly clients. And so my incapacity clause was one paragraph and probably sufficient in generally. But as I began working more exclusively with my elderly clients, I realized that one paragraph incapacity clause was not sufficient. So now my incapacity clause in my revocable trust is 3 pages. So depending upon the specialty of the attorney, you have different trusts. They're not, in other words, they're not all the same. And anytime if you engage an elder law attorney to review your documents, you may find that additional items are put in there that the other attorney never even thought about because they don't work with elderly people.
Okay. How much does it cost to set up a revocable trust for elderly parents?
I would say probably the average in town is somewhere between $2,000 and $3,000, something like that. We don't do a la carte estate planning. We do it more as a comprehensive life care planning program. So in addition to the trust and the wills and the powers of attorney and medical directors, you also get an elder care coordinator, a nurse. You also get a complete financial review and a complete maintenance program to make sure everything is kept up to date and looked at on a regular basis. And so it's much more comprehensive.
Frequent meetings.
And frequent meetings. So yeah. So, but if you were just going to go out and do an a la carte, just hire an attorney to do a trust, you're probably looking, I don't know, with the community somewhere between, although I saw in the newspaper somebody was advertising $1,500 or $1,000 or something, and you could go up to $4,000 or $5,000 depending on if there's tax planning involved. So it can vary.
Okay. Okay, I think we've asked this before. Can you list companies such as yours on the Big Island?
No, I'm not aware of any life care planning. Actually, I believe we're the only life care planning firm in Hawaii. We're a member of the Life Care Planning Law Firms Association, national organization of life care planning law firms. And I'm sure there are attorneys that work in elder law on the Big Island, but they don't do what we do.
So that'd be another Google search on the Big Island, yeah.
Yeah.
Is it sufficient and safe to use the advanced healthcare directive forms available online?
Generally, yes. The ones online are oftentimes geared locally, and the Hawaii statute for the Advanced Healthcare Directive had a form, a statutory form that you fill out the blanks and check the boxes. But we think that a Advanced Healthcare Directive should be supplemented with much more detailed information about what your final wishes would be. And so that's why we use that Your Way form. That's why the 5 wishes and some of these other supplemental forms are valuable. And actually the Advanced Healthcare Directive can fall into 2 categories. Kind of the one that you see frequently is where you check the box whether or not you want to have continued care if you fall into certain circumstances, like if you're in a coma or if you're in a persistent vegetative state, you want to have life support. But there's another kind of advanced health care directive where the client says, I trust my daughter, I trust my son to make the decisions. And so I want to give them the authority to make all the decisions. And I'll tell them what my thinking is, and I'll fill out one of these forms so that they can, these Your Way forms to inform them, to help them make the decision. But I want to leave the final decision up to my son or my daughter. And then they don't check the box on which kind of care they want to get. They give a much broader expansive authority to their child, and it's an advanced healthcare directive. Others will say, no, I don't want my child to have to decide whether to pull the plug. I want to make that decision, and so I'm going to put that into my form, and they have to abide by it. And that's a different kind of form. So there are different kinds of advanced healthcare directive forms, but you can, I think the one that you get off the online, and you can get them free too from if you go to Straub, they have a form. If you go to Kaiser, they have a form.
Kokua Mau has a very good form.
Kokua Mau has a very good form. So you can get online forms from Kokua Mau. You can get them from your medical care provider, or you can get them online, and often those are geared for local, depending on what state you're in. You can click the state and you get the form that's commonly used in that state. And that's better than nothing. Do that. That's good. I think it's better to have it more thoroughly reviewed and do a supplement to it, but at least that's a good first step.
Yeah.
Right. Okay, if I already have Vietnam VA benefits, will I qualify for VA aid and assistance? That would be a yes, yeah.
It depends upon, again, income and medical expenses, and there's a lot of math involved in this. There's a lot of calculating countable assets, and there is now a 3-year look back period for aid and attendance. So I would say this is something that you need to get some help with. The VA doesn't always have good advisors available. We have found that there's a lot of misinformation out there, and the whole aid and attendance program was revised just a year ago. So you need to get some real educated advice about whether or not you would qualify.
Okay, referring back to Social Security, you said that they have a separate power of attorney form. Are you referring to collect Social Security benefits for your loved ones, or is it to terminate when your loved one passes away?
There's a representative payee status that that's the form that you would need to submit in the process you would need to go through in order to be the custodian of your loved one's Social Security benefits. There are strict fiduciary requirements to make sure you don't abscond with the money, but that's what you would need to do in order to be able to talk to Social Security to make sure benefits are being paid regularly, and if an adjustment needed to be made, they would need to know you have the authority to speak on behalf of your loved one.
I'm already getting Social Security benefits. Do I still need a power of attorney?
Yes, a power of attorney is not just devoted to Social Security. A power of attorney names an agent to manage financial affairs for you, whether it's bank accounts or investment accounts, your real property, a wide scope of financial decisions comes under the responsibility of the financial agent.
Okay. How often should the revocable trust be updated or reviewed?
It should be reviewed, I think, at least annually. And there may be situations that would require reviews earlier. For example, the successor trustee that you designated becomes ill or moves. One of the beneficiaries that you've named in the trust has turned the corner and is no longer appropriate. Maybe has now a special needs, and a special kind of trust needs to be set up for him. So as circumstances change, as the financial situations change, and as the capability and availability of the successor trustees change, then there may need to be a update or review. But I think at least annually, it should be reviewed to make sure that everything is still up to date and and is consistent with current law.
Okay. What about Sterling and Tucker?
Good for them. Yeah, they do a lot of work in the benefits planning and Medicaid planning, and as far as I know, as far as I've seen the work that they do very competent, good work.
They don't have elder care coordination as part of their work, though.
No.
Okay. Any advice how to transfer assets before application of Medicaid?
Medicaid is going to be looking at the possibility that you have given away your assets in order to qualify for Medicaid. So transfers are going to be examined, and they're going to presume that you have given them away in order to qualify. So you're going to have to document, if transfers are made, you're going to have to document very completely why the transfer was made, for what purpose, and there should be fair market value paid for whatever asset is being transferred.
Yeah, there might be, when you say transfer, that brings three possibilities to mind. One is a transfer that's a gift. Any kind of a gift there's a 5-year look back period. That creates a penalty. If there's a transfer that is for consideration, a transfer that you get paid, that's a sale. It's a transfer, but it's a sale. That doesn't disqualify you because you've replaced that asset with another asset, the money. And there's a third kind of transfer, which is a kind of like an internal transfer, a transfer of a countable asset into a non-countable asset, but you still own both. But one then qualifies you, by doing that, you may then qualify for Medicaid. So there are some exemptions for an adult child who cared for you for 2 years prior to your moving into a nursing home, a sibling who has been partial owner of the home. There are some ways to document that the transfer of the asset has fulfilled the requirements of the exemption. Yeah, like if you had a brother or sister that's a part owner of your home, and you could transfer your ownership to your brother or sister, as long as they live there for at least a year, it's exempt.
Right.
Transfer to a caregiver child is exempt.
Okay, and the last question, these are wonderful questions. I mean, the
yeah,
pages
they're
of
very
them.
good questions.
Yeah. The representative payee from Social Security requires a note from the doctor that says your loved one cannot make, oops, I got another question. Okay, that says your loved one cannot make decisions, and many doctors shy away from that. Do you want me to read that again?
It is difficult because a lot of doctors now, we understand the Kaiser system, the doctors won't sign statements of incapacity because there's some potential liability attached to that. We have had, in some cases, had to refer people to psychologists, geriatric psychologists, to get a mental status exam. It's expensive, it takes time, but that's correct. Sometimes doctors will not sign a statement. It's distressing, but it's true.
Are geriatricians more apt to do that as opposed to general PCPs?
I think so.
Probably.
Geriatricians are much more, their specialty is working with elderly folks
And they
persons that
understand
have,
capacity issues.
yeah, they understand the capacity issues, right?
Yeah.
Okay. If you have assets and insurance, long-term care, et cetera, should you still consider Medicaid?
Yes, part of the long-term planning is that what if you run out of money, or how can you reposition assets so that you can accelerate the qualification for Medicaid if it's needed. And that's part of the planning that's done. And different elder law attorneys approach that differently. Our goal is that we make sure mom gets the best available care. And whether the kids inherit anything is like fifth on our list of priorities. Our number one priority is mom, is our client.
Right. And dad.
There are some elder law attorneys that are really kind of employed by the children to try to protect their inheritance and impoverish mom so she can qualify for Medicaid, go into a nursing home, and they can end up with the home and the other assets. That's not the kind of work that we focus in on. That may be an ultimate result of certain kinds of planning, and it may be that that's what the parents' wishes are. But our goal is to make sure mom gets the best available care. And as I mentioned, the kids are fifth on the order of priority as far as their inheritance. So there are ways to plan, and there are ways to plan.
And every case is different.
Yeah. Okay. This person just wants to make a comment. When people transfer assets for Medicaid eligibility, it becomes a burden to every taxpayer. Also, the golden days of Medicaid are gone and services are much more limited. Would you like to comment on that?
Yeah, I think that's true. When a person does the kind of planning that qualifies them for Medicaid, Medicaid is paid for by the taxpayer. And so we want to make sure that planning that is done in a responsible, reasonable way. Our goal is to make sure that our client gets the best available care. And when a client gets into a nursing home and the nursing home doesn't provide everything, they don't provide for dental care. There's other services that they don't provide. And sometimes they're not looked after as much as we would want. We'd have a client maybe having to share a room with another person. And so to the extent that the client has assets, if we can reposition those assets so that they're available to augment and excel and improve the care that client gets in the nursing home, then that's our service to that client. But you're absolutely right. Just like any government benefit program, that's paid for by the taxpayer. And
so it goes.
so there it goes.
Okay, you've gotten a bunch of really nice thank yous and very comprehensive and well done. This one says, this has been so helpful. I realize I need to start my own planning as my husband and I do not have children to help plan for our care in the future. Thank you for taking the time to do this.
Oh, you're quite welcome.
Thank you very much.
And I've learned a lot too, but we're still not through. Okay, what's the minimum net worth a client might have to be able to afford life care planning?
Oh, what was that? You had another question.
What's the minimum net worth of a client that might have to be able, what's the minimum net worth a client might have to be able to afford life care planning?
We don't have I don't know that there's an answer to that. We do work on a fixed fee basis that covers everything we do for a year at a time. The output in the initial year is greatest because most of the work is done in the first 6 months, gathering information, evaluating, doing assessments, bringing things up to date, making recommendations. But after the first year, the renewal fee drops way down. And if we can, in the first year, even though the fee is higher, if we can perhaps save a month or two's nursing home costs because of good Medicaid planning, well, that will have paid for our fee. They will have gotten great value from it.
Yeah, and often
different.
Well, oftentimes it's not the client is our client, and because of legal rules, they're required, we're required to collect our fee from our client, but but the net worth of the client isn't relevant. No. It's the kind of services that we can provide to the client that are relevant, and oftentimes the kids will reimburse mom or give mom the money to pay for the long-term care because they see the value to them of having mom being properly prepared and looked after. And so oftentimes it's the family together that pools the resources to be able to hire us. Mm-hmm. And there are, like Gary Powell can step in and do a lot of, for a person that's really in poverty, Gary Powell can step in and do a lot of help as well as a nonprofit. Mm-hmm.
Thank you for watching out for our parents and not the kids' inheritance. I like that. Okay, and then aloha nui loa. I'm a former attorney, and I found this presentation very helpful, including raising a lot of helpful questions we should be asking. You mentioned that having joint account or agency account at the bank will give my child the ability to pay bills in case I'm incapacitated while I'm still alive. If I have all my bills set up for automatic withdrawal from my bank account, so I still need this joint account or agency account, and what else is it good for?
Well, I think that's a good plan to have automatic bill payment from your account, but there's also, unanticipated expenses that could come up. You may be a need to hire a caregiver to come in part-time, and that may not be covered by an automatic payment. You may be paid directly to the caregiver or the caregiver agency. And so there may be additional expenses or bills that come up that were not anticipated or that would not be covered by a automatic payment provision, with the bank. So it's still a good idea, I think, to have a reserve fund available for, like emergencies, for unanticipated expenses.
I came here for my mom, but I realize I need to address it for myself also. Thank you to Tom and Lori. The big thank you to Kathy. But okay, that's just thank yous. Okay. More thank yous, more thank yous, more thank yous.
You're welcome.
What is the fee for the first year? If you would rather not answer online, please leave us with your phone number. Okay, you have their email address and phone number on the flyer that I sent you with their bio. And Kim Ong is their elderly care coordinator at their firm. That's on the bio as well. And that's it for questions. That was wonderful, guys. I mean, I've heard you speak so many times, and I still learned more today. So, and I have more guilt, of course, but I'll take care of it. I'll take care of business. And thank you for everybody that stayed. There's still a large number of people still on. So the questions were wonderful. I hope you guys got a lot out of this. And it is being recorded, and it will be available probably by Monday because it takes a couple of days for the cloud to get it up there. So I'll send you information for next week. And Look forward to seeing you again then. Tom and Lori, thank you so
Okay.
much.
Thank you all. Thanks, Kathy.
Bye-bye.
Bye.
Bye.
Okay.
Hau'oli, aloha.